Good afternoon. I'm your host, Brian Buckmire, here at the Law and Crime Report. We begin with the NXIVM leader, Keith Raniere, who was sentenced to 120 years in prison for leading a sex cult. Now, he's been charged with a number of crimes, but it mainly has to do with his participation in being a part of a sex trafficking ring that attracted millionaires and many Hollywood actors. Here's a U.S. acting attorney at the time who spoke during Raniere's case in the sentencing phase.
It was a compelling proceeding. I'm sure you would feel the same if you heard the victims address the court. To be clear, just a few minutes ago, Keith Raniere was sentenced to 120 years in federal prison by United States District Judge Nick Garifas, who's the same judge who presided over the trial. It was a 6-week trial, as you may recall, and the defendant, Keith Raniere, was convicted of all counts at that trial, including racketeering, and it was today that he received the sentence which holds him accountable. It is our sincere hope that today's sentence does deliver some measure of justice for those victims who suffered in immeasurable and numerous ways. Hopefully brings some closure to them. Certainly the judge's sentence, which in effect incapacitates Keith Raniere for the rest of his life, should hopefully give them some sense of security and should stand as a warning to others who would participate in similar like conduct, that when justice catches up with you, as it did today, it is severe. Keith Raniere will not be able to victimize people anymore after today's sentence, and we're very grateful for that. Also, it struck me in listening to the victims that Raniere really, twisted people's trust in their need to find some meaning and hope in their lives in just the most insidious and devious ways. And it just shows that anybody with whom you share your trust can hurt you and hurt people. He certainly did. But the victims were resilient, remarkably so. We're grateful for that, that they stood strong. And were able to address the court directly. The judge certainly considered the facts that were in evidence. He considered the evidence of racketeering, sex trafficking, sexual exploitation, child pornography, extortion, fraud, money laundering, and related crimes. It was clear that the judge took all those things into consideration in fashioning a sentence, that he considered that evidence and he listened carefully to the victims.
All right, so I'm joined by two defense attorneys here. We've got Melba Pearson from Miami-Dade, Florida, as well as Jonna Spilbor, who's here in New York. Good morning, or good afternoon, sorry, to you both.
Good afternoon.
All right, so let's jump right into it. We're talking about 120 years, but for a 60-year-old gentleman, that's basically life. He's not getting out anytime soon. Jonna, I start with you. The acting U.S. attorney there gave us a laundry list of charges and the ultimate amount of 120 years. When you hear that number based on the allegations, or sorry, the lack of allegations, because now they're founded facts after the jury came back, does that number make sense to you? Do you agree with that number? Do you see it too high, too low, or just right?
Well, obviously it's high. Anything that's going to put somebody away, he could be 2 years old and get sentenced to 120 years, and that's a life sentence. The judge, I believe, came out in this case and said that they were trying to send a message, which that part concerns me. The second part that concerns me is, of course, whenever you have almost any length of sentence, there's going to be an appeal here. And when you sentence a person to 120 years, you're inviting an appeal. And I think this particular defendant is still contending that, look, I didn't do anything wrong. This was my lifestyle. It's not a crime to be a cult leader if he even admitted to being a cult leader. So you can bet we have not gotten to the finish line in this case yet.
Oh yeah, there's definitely going to be an appeal here. He's actually maintaining through his lawyers his innocence, saying that he was a self-help guru in a sense, not the person that this court case demonized him, and I'm putting quotations as how he's putting it more so, ended up being. Now, Melba, let's bring this to you. I know sometimes we as defense attorneys don't like the fact that our clients are made as an example, but in some sense, all sentencings are examples. They're supposed to let society know this is bad. I mean, jaywalking, you maybe get a slap on the ticket or a ticket. We know that's not as bad as for example, murdering someone. So do you find any problems with him being an example to other people, or does it kind of fit the storyline of how the criminal justice system works?
So I don't see a problem with him being used as an example for the specific reason that he was someone of privilege. He had wealth, he had access. He was hobnobbing with presidential candidates and, the elite, the rich and famous of our country as well as internationally. So we don't want anyone to believe that they are above the law. And it's not okay to basically create what he did, basically a multi-level marketing strategy where the way you ascend through this cult is to entrap more young women and bring them in as sex slaves. So this went way beyond just having a different or an alternative lifestyle. This was about deliberately manipulating and selecting certain victims so that he could fulfill his own needs and desires. And if this is not done in a consensual manner, and certainly some of his victims were not of the age that they could consent to this, now you have a problem. So I think the 120-year sentence was to be a clear signal that human trafficking is not going to be tolerated. And it doesn't matter how much resources you have, how much money is in your bank account, you will be held accountable in a court of law for harming other people in this way.
Yeah, and Jonna, the sad part is this saga is not done. They might have gotten the quote unquote head of the snake or the top guy in charge, but we know that like Claire Bronfman, who took a plea deal to avoid major jail time, and we have Allison Mack, who's also tied up in this. She's not sentenced as yet. Do you see that there may be more arrests or more charges down the line for more people who are involved in this group?
That's really interesting because historically, once we do get the head of the snake or the top dog or, the top gun in cases like this, that's what prosecutors are striving for. And if they don't need anybody down line to do that, then you could say that, all right, well, this case is solved and they move on to the next one. And I don't know if there are any other big fish in this case that they're going to be going after. And you can bet that if there were, they would want to get some of the people who are under him to start talking. That's historically how this works. But I'm not getting that sense. Correct me if I'm wrong. We could see what transpires, but they got their guy in this case is my feeling.
Yeah, and I was surprised that we didn't hear a lot of discussion or anything about someone flipping on someone. There wasn't a lot of that here. Melba, should we be reading into that? Because oftentimes you hear about these long list of charges, these large organizations, and someone's flipping to get either the top guy or something. Was it just that the evidence was so strong that it didn't need it, or was something else maybe at play?
I think there could be a few things at play. Number one, obviously, if you've got the victim survivors who are able to testify and give dates, times, and there's corroborating evidence, whether it be through cell phone records or surveillance videos or anything like that, web searches, Facebook posts, anything like that to corroborate, that's one aspect. But what I'm thinking most about is the psychological aspect. I think that especially when you look at cults, there's that bonding, almost like that Stockholm syndrome type of mindset where even though this person is harming you, you are still feeling a sense of loyalty to them. So I think much like you will see in many domestic violence situations, you have situations where the person who is surviving the abuse is not yet ready to testify against their abuser because of issues of love or finance or fear. There's many things that go into what's known as the battered person's experience. So I liken that to what's happening here, that maybe some of the folks who have intimate knowledge of what went on behind closed doors and have been charged are still yet not willing to come forward because he still has that spell over them, so to speak, and they have not been able to fully break with him emotionally to be able to turn and testify against him. So I think it's a matter of the strength of the evidence as well as the psychological aspects that may be preventing these women from flipping on him.
It's going to be interesting to see how that plays out. Of course, he's already sentenced. There's a long list of individuals waiting to be sentenced. I think for many of them, they're going to be pointing the fingers upwards and hoping that because, as Jonna was alluding to, the top dog is already caught, they're going to try to skate through on lesser charges, lesser jail times, but we're obviously going to keep you up to date as those cases continue. Last question before we move on, though, Jonna. We still have a lot of support for him. People are coming out and still saying he helped me change my life. Do you think that support may help in the appeal that we're all anticipating is going to happen?
Well, yes and no. We got to keep in mind the appeal is really going to be strictly on what happened inside that courtroom during his trial. You know, was there any evidence that got in that shouldn't have, et cetera? But can I bring back a point that Melba made, because this is a fantastic area to kind of dig into, and that is, for lack of a better word, when do you actually become a victim? So, for example, you say, and I agree with you, there are people who still think, hey, wait a minute, I wasn't victimized by this guy. He helped me. He did good by me. And then you have obviously a whole other camp is like who says exactly the opposite. No way, he sucked me into this hole and then he abused me. At what point do you cross that line? If you go into a situation where you have kind of a, let's say, alternative lifestyle, and even if you're doing things that might be, as he himself put, distasteful or disgusting or what have you, when does that cross? When does that become a victimization as opposed to a decision? And I'm just throwing that out there. I'm not saying these people weren't victims at all. I'm saying there is that line that gets crossed at some point. And where is that point? Why does he still have people who support him and other people who participated in whatever they participated in and say exactly the opposite? That's the struggle for the jury. Obviously, they got past it, but that to me is the most fascinating thing about a case like this.
Yeah.
And I think that's what's so crazy about the whole cult situation, because, you know, and also as a parallel, you look at the situation of R. Kelly that's still pending, as well as Bill Cosby. Obviously, that's a closed case as well. You know, not everybody who goes into that situation may necessarily have been victimized or had a bad interaction, right? But then there's a whole other group of folks who may have been victimized in a different way. So, you know, there's so many varying experiences. And then again, also consent. What did you sign up for? Maybe you signed up for consensual sex. Maybe you signed up and turned over your life savings willingly, thinking you were going to get something. So it's very nuanced. Definitely.
Exactly. Not everyone there was a victim, but it doesn't mean that there doesn't exist victims. We're going to take a quick break and come back with more here at the Law and Crime Report.
It's upsetting, but somewhat to be expected. I mean, we've never been through a trial before, but we watch TV, so, you know, we know that this is going to take time. It's just kind of like a punch in the gut every time he gets to walk out and just be free and live his life. It just seems so unfair, because she doesn't get to ever walk this earth again, or, you know. I mean, it's been 10 years and now we're in court, and we're grateful. We're so thankful that she was found, and, you know, that he's having to face consequences finally. You know, we just want him to tell the truth. I was saying that in there with Scott O'Reilly, the prosecutor. I don't care about any jail time. If he would just tell the truth, tell us what happened, you know?
All right, so that was the sister of the victim in the Jacob Bumpus case. Her name is Paige Johnson. She was a Northern Kentucky teen who went missing back in 2010. Now, Bumpus has been now indicted on the charges not of homicide or murder, what we all would suspect, but instead on tampering with evidence and abuse of a corpse. And that predominantly is because there is no manner of homicide. They cannot figure that out as yet. So it's not to say that it will never happen, just at this stage and this point, they can't prove that charge as of yet. Now, the remains were found in Ohio, so the charges are coming up in Ohio, even though she was a Northern Kentucky teen. Let's bring back on our guest. Let's talk more about this. Let's go first impressions. Melba, you heard this story. Northern Kentucky teen, remains found over a decade afterwards, and now we're finally connecting the dots. What were your initial reactions?
So first off, my heart just breaks for the Johnson family, because to be in limbo for 10 years, not knowing where your loved one is, not knowing whether they're alive or dead, I think that's probably the worst type of torture to have to go through as a family. At least now they have an answer. They have, unfortunately, a body. So at least they can have some closure from that aspect. They know, unfortunately, she is not coming home. But then the question is, what actually happened to her? And the problem when you have a body that has been, possibly exposed to the elements and there's been some decomposition, it makes it very, very difficult for the medical examiner, the coroner, to figure out what exactly happened. So hopefully there'll be some advanced testing that can help narrow down some of the potential causes. But, it's definitely a heartbreaking situation. And obviously, we have to figure out what role did the defendant play in this, right? I mean, was he just merely present? Did he actually kidnap her from Kentucky and take her over state lines? Where was she actually killed? Was she killed in Kentucky or was she killed in Ohio? We know that, she was found in Ohio, but the question is, where is the actual scene of the crime? Because these are all things that are going to need to be presented to the jury for them to be able to come back with a robust verdict, especially one with regards to the charge of murder. But at this juncture, the state is not in any position to move forward with a murder charge until they have some more information from the coroner and some more details, hopefully a confession, but some more details about what really happened to Paige Johnson.
Yeah. And Jonna, some of Melba's questions, I think, are the questions that we're all asking, but could also lead to multiple ways that this case could be tried. Because as we know, Johnson went missing back on September 23rd of 2010, and Bumpus was the last one to have seen her. He claimed to have dropped her off at a specific location. Fast forward 10 years, the evidence is showing that his cell phone pinged at a specific location about a mile or two from where her body was found, and that's how we're putting the connection. But if we find out that she was murdered in Kentucky, he could be facing murder charges in Kentucky as well, correct?
Well, let's back up a second, because this case is going to be fraught with truth problems. We don't know whether she was murdered, whether she met with some accidental death, where that happened, how it happened. Did somebody cause that? Did she, choke on a grape? Like, we have no idea what happened. And when you have evidence that is over 10 years old and has decomposed over that entire time, you got to hope as a prosecutor that somehow your cops are going to get a confession. Maybe you can offer to sweeten the pot somehow to get a confession, and maybe, I don't know, maybe he never gets charged with murder. Maybe he gets charged with some sort of manslaughter for a lesser sentence. You have to, as a prosecutor, also listen to the family. Her sister, right? This poor victim's sister said, and I hope she doesn't mean it, but she said, we don't care about jail time. We want to know what happened. That's code for we want closure. We want to know what happened to our beloved family member. And this guy, we think, is the only one who can tell us that. And we don't even know that for sure. So you've got to be really in tune with what's going on with the family here, keeping in mind, juxtaposing that between what's probably going to be a proof problem beyond measure, and then do the right thing as a prosecutor in this case.
Yeah, there's going to be a lot of legal issues there for the prosecutor. The defense is going to really push forward identity. Where did this happen? Is this the right person? And that's going to make for an interesting battle between both sides. But we'll make sure to keep you aware about the evidence that comes out in that case as it spills out. Let's switch gears now, just ever so slightly, where a grand jury member in the Breonna Taylor case say that the actions of the officer that night were quote unquote negligent and criminal. Let's listen to some of that more and see how that was broken down.
One big question surrounding this case is whether or not the officers knocked and announced their presence. Talk about the evidence that you came to that they did announce their presence.
Yes, the statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to apartment 4, who corroborated that information and said that there was a knocking and announcing by the officers.
Was the witness a civilian or a law enforcement?
The witness was a civilian.
All right, so before I throw it to both of our guests, and this is, I think, maybe at the center of a lot of the issue here with the Breonna Taylor case, it's when you take the Attorney General's statements and you line them up with what the grand jury minutes say, what now these two jurors are coming out, that doesn't make sense. Because the officers, yes, they say they knocked and announced, and the person who confirmed, when they first spoke to him, he didn't confirm that he heard a knock. When he said it, when he spoke to them a second time, that's when they're saying, well, he changed his story. But both times during the grand jury, they said, well, there was a language barrier. We don't know what language he actually speaks. He's American, but we had difficulties understanding him. And every other person who lived there and was brought towards a grand jury, they all said they didn't hear a knock. To me, that's still up in the air. That's not a confirmed fact. And that, I think, is what people are really picking up on Attorney General Cameron. But let's go to our guest. Melba, let's start with you. We have grand jurors coming out saying, quote, they were negligent, they were criminal, they were not given homicide charges. When you hear what Attorney General Cameron said, when you hear what these anonymous grand jurors are saying, and the information you know so far, how are you putting this all together?
I have very, very grave concerns about what occurred in that grand jury room as put forth by Attorney General Cameron. There is a sweet spot, having been a former prosecutor, when it comes to presenting information to the grand jury. You don't want to give them every single thing that's in your file because some of it may not be relevant and may serve to confuse them. That was sort of the allegations made against then District Attorney Bob McCullough in the Michael Brown case in St. Louis. So, but you can't also go the opposite extreme and give the grand jury nothing to really consider. So, because at that point, now you're trying to craft and push their findings to a certain charge. And if that's what you intend to do, then take the bull by the horns and file charges yourself and just, take all that comes with it and just say, listen, I analyzed the case and this is my viewpoint as to what the most appropriate charges are. He basically, it's sounding to me like he manipulated the grand jury to make sure that lesser charges came out of that process. And that is a miscarriage of justice if in fact that's what he did. Because again, at the end of the day, the jurors were like, listen, there's information that not only that we learned about in the grand jury process, but also, hearing about generally reported in the media. This does not square up with the statements he's making in public, which is why these grand jurors felt the need to come forward to clear the record and say, listen, this is not what he presented to us in the grand jury. We were not given a full array of options as to what charges we could pick from, what charges we could bring forth in an indictment. And he's misrepresenting, our findings. So this really is not a good look at the very least for AG Cameron. But at the same token, when we're in such a fraught place in our country, this is not the time for mistakes. This is not the time to try to protect people. You give the grand jury the tools they need to do their job effectively, and you let the chips fall where they may.
Jonna, same question. We're hearing from these two anonymous grand jurors. We heard from Attorney General Cameron. And based on that and the information you have about this case, how are you putting this all together?
I agree with much of what Melba said, by the way, but I also have to look at this from a criminal defense standpoint, right? Normally, when we are up in arms about something a grand jury did or didn't do, it's from the place of a defendant who claims that they've been overcharged, that the prosecution gave too much information, that the prosecution threw everything at them but the kitchen sink. And it's from the defendant's standpoint that we attack the grand jury findings. This is sort of flipped on its head. Here we don't have a defendant contesting what happened in the grand jury. We have the public contesting what happened in the grand jury. And instead of saying this person was overcharged, they're claiming these people were not charged enough. And that's a very unusual stance. And in a sense, there's no, quote, standing for that. Like the only pressure at this point is going to be the public pressure on the Attorney General. And look, if I may play devil's advocate, if you're charged with jaywalking, okay, you're not going to, and jaywalking is not something you wouldn't be indicted for, but I'm oversimplifying. If you're charged with jaywalking, it's incumbent upon the prosecution not to present evidence that of robbing a bank or theft or shoplifting, because that had nothing to do with your jaywalking. And I think what the prosecution here is trying to say is, look, we had clear and convincing evidence of self-defense. We had clear and convincing evidence that bullets were shot at the police officers. We had to take that into consideration. And we did not think we could prove a murder charge based on that. Therefore, we did not present it. And That is also a plausible theory. I can see the arguments on both sides of this clearly. And who's right? Who's right?
Right. So let's play a little devil's advocate here. Melba, first with you. You're a prosecutor. Attorney General Cameron can present facts or evidence however they want in the grand jury. There is no law that says how he is supposed to do his job. So if he does a great job or a poor job, it's still his job and we got to live with it. Is that not the answer here then?
Yes and no. So correct. There is no rule book as to what you're supposed to do. And maybe there should be, right? Because then that way we won't have these situations where the public is like, well, we don't understand this process and we don't understand what the burdens are or what can be brought forth. I think that if we had more standardization and also more transparency around the grand jury process, because as most folks know, the grand jury process is all done in secret. So that's why the grand jurors are, coming forth anonymously. And that's why, there was all of this public outcry to be able to actually see the minutes to be like, okay, what actually happened in that room? So that lack of transparency and everything being shrouded with secrecy just adds another layer to the distrust that many have for the criminal justice system. And look, at the end of the day, we can't avoid what the main issue is here. We're in a period of time where people are tired of seeing people getting killed by police officers, and there seems to be no accountability on the back end, right? If you see somebody in your neighborhood commit a homicide, within 24 to 48 hours, they're going to get arrested and they're going to be prosecuted to the fullest extent of the law. Now, when we look at the issue of police officers, you don't see the same sort of transparency, accountability, or at least an explanation as to really what happened and what evidence is at play. We know that the vast majority of police officers do the best that they can each and every day, put their lives on the line for our safety, and we're appreciative of that. But when we see situations, especially like this coming in the wake of the George Floyd situation, where a man was literally killed in front of, the entire American public watching, again, when you have an attorney general that's being secretive and then also deliberately misrepresenting the evidence as well as what was presented, now you have a problem. And at the end of the day, the voters don't have to live with it. The attorney general is an elected position in the state of Kentucky. So if the people of the state of Kentucky are not pleased by his performance in this case, they don't have to live with it. They can vote him out in the next election.
Yeah. Well, unfortunately, we got to take a quick break. I know we really want to get into this, but the one thing I would have said, Jonna, is that you hit the nail on the head that it's almost flipped upside down, that the public is pressuring for greater charges. But it's only flipped upside down because the attorney general flipped it upside down. I've said in the past, with attorney generals like that, who needs defense attorneys? Because that's not typically how it works. They typically go for the greatest charges and we fight, but he didn't do that here. And why does he only do it for one type of defendant? That would be my question. But we're going to take a quick break and come back with more here at the Law and Crime Report. Welcome back. Brandon Martin, once a MLB baseball player for the Tampa Rays. Now he's being charged with 3 murders, that of his father, his uncle, and the security guard who was there at the time installing a security monitor to potentially protect against something just like this happening. Now, let's take a quick look at the prosecutor's opening statements in this case as we are following this case step by step.
You will find out that Ricky Anderson died of multiple blunt force injuries inflicted by the defendant, the force of a professional baseball player, wielding the instrument of his profession as an instrument of death. Barry Swanson, a man who truly was in the wrong place at the wrong time. You will find out that Barry worked for a subcontractor of ADT called Defender Security. And you'll find out from the records we have subpoenaed that that company was contacted on September the 16th, 2015, one day after Sandoval had taken the defendant to ETS, and one day before the murder, they had been contacted by the defendant's mother, Melody Martin, and she had requested an installation of a security system. And he being Barry Swanson, was assigned that job order, and he turned up on the morning of September 17th to install the security system requested by Melody Martin.
Now, the prosecution came with all of the facts that they intend to prove in this case, and the defense did the same, and we'll show that in a moment. But let's begin here. Jonna, this is a gruesome case, but in the backdrop, there's also this failure of the government, I think, that the defense is going to push forward, especially in the second phase of this trial, that being the penalty phase, because there seemed to be a great lapse that he was admitted to a mental health hospital. He was 5150 and should have stayed there for 72 hours, got released after 48 hours. And the tragedy of this is not just in the father and the uncle died, but the person who's installing the security to potentially stop this from happening in the future, he's a victim as well. How do you see this is going to play out in this trial as we have both of those in the backdrop?
Yeah, this is such a sad case. And I think it's something that actually can happen more often than we believe. And what a slow boil. You know, this defendant had the potential for greatness, right? And how lucky for him. And then just started to slowly unravel. And behind the scenes, you have the turmoil that his parents are going through, because as an adult, you have no control over what your adult children do in terms of taking care of their mental health or their physical health for that matter. And they saw the unraveling, and it scared them. It scared them very badly. And they tried to take steps to protect themselves. They can, point to the county for not keeping him involuntarily institutionalized for long enough, not for him not getting the treatment that the state could have provided for him. And then right on the cusp, it's like they're trying to outrun the potential danger of their own son, which must have torn at their heartstrings, and they're too late. Not only does the father end up dead, the uncle end up dead, but a perfect stranger, wrong place, wrong time, end up dead, all because this defendant was mentally unraveling, and nobody and no thing could intervene sufficiently to stop it. That's a tragedy, again, beyond measure. Look, he had the world, he could have done anything. And unfortunately, this intervened, and with the worst results possible. It's tragic.
Yeah, it's heartbreaking all around. It's not like many of our cases where it's so black and white, good and evil type of thing. There's harm all around, especially, and it happened to in a family. Let's listen to the defense attorney's opening statements in this case as well.
We're going to see a picture emerge of Brandon Martin, a picture that shows that between 2011 and 2015, his mind was changing. He was decompensating. He was going through things that he could not control, that his family worked very hard to attempt to work with. And it came down to, on September 15, the family at wit's end called law enforcement, said, help us. Mr. Pearson said law enforcement gave them two options. They didn't like either of them, but of course the least serious of the two, let's commit it, pursuant to Welfare and Institutions Code, Section 5150. And you'll hear that the law commands, when somebody is committed for a 5150 hold, they are to be held for 72 hours. And as Mr. Kearse laid out to you, Brandon Martin was in the ETS for less than 48 hours. Mr. Kearse argued to you, and by the way, this is not a time for argument. Mr. Kearse argued to you that he was abandoned by his family, and no, that's not the case. You'll hear evidence about that. But there is no question that Mr. Brandon Martin was going through significant mental health issues that were attempted to address, but then less than 48 hours later, he was cut loose, sent on the street. Here's a bus pass, but don't go home. Or else you go. This is not an opportunity for me to argue how you should interpret the evidence presented. I will have that opportunity at the end of this trial. But this is my opportunity to stress that you keep an open mind.
Now, Melba, in my lifetime as a public defender, I've prepped one case that potentially I was going to argue mental disease or defect or insanity, and it's not an easy hurdle to overcome. But as I listen to the facts of this case, I've never heard a case with more beneficial facts that will go towards your argument that the person standing or sitting next to you has a mental disease or defect. We're talking about witnesses that have already testified to a deteriorating, just mental capacity, that one day he was the next Derek Jeter, family members would say. And the next day you look at him and it was just evil in his eyes. He would fly off the handle, drugs, alcohol. The reason why he was in a mental health facility is because he attacked his family. And the family said, we don't want him to go to jail. We want him to go to a facility. And to Jonna's point, they were trying to find that sufficient help. And he's released 48 hours. It appears the family was not notified. He gets released, and the worst thing imaginable happens. And I'm listening to the defense attorney and I'm thinking, so when are you going to use this as a defense? Like how is this? It doesn't make sense to me. Does it make sense to you at all?
It doesn't, but then again, there may be more to the story. So behind the scenes, how cooperative is the defendant with regards to helping put forward this mental illness defense, right? And also, what happened with any evaluations that have been done by court-appointed experts or independent experts? Would they be able to say that he did not have an appreciation for right and wrong in that instance? And if they don't think they could get that sort of finding, then they may have felt that they're better off just making the argument to the jury that he is someone suffering from mental illness, and therefore, this should be a mitigating factor in his actions. I don't think that this should have been a death penalty case. I understand death penalty is on the table because clearly, no matter how you cut it, this is someone who is struggling very severely with mental illness. It could have been something brought on by something along the lines of depression brought on by losing his contract, or it may have been something even deeper than that, like a manic depression or something along those lines, which may have caused him to lose his contract with Tampa. But at the end of the day, there are a lot of facts here for the defense to be able to use in order to at least make sure that the defendant receives life in prison. Because at the end of the day, I don't think that there's any question as to whether or not this is going to be a guilty verdict. This is going to be a guilty verdict. The question is he going to end up with life in prison, or is he going to be put to death for his actions? So, I think there may have been more things in play that resulted in not using true mental illness or saying that he was insane at the time of the offense, because they may not have been able to meet all of the legal criteria that is required.
Yeah, and Melba, thank you for that. That's really important when it comes to like the legal standard as to whether or not to comply. And we got to take a quick break, but I want to credit Jonna as well, because during the break you were also talking about, or both of you were talking about, whether or not the client will actually go forward with this. Are they going to participate in a meaningful way with your case if that's your theory? And if their client's going to be jumping up and down saying, I'm not crazy, or not allowing you to go forward. I think to Jonna's point, you said people think we control the scene, but we don't always control everything. That's not going to be helpful. But we got to take a quick break, and we'll be back with more here at the Law and Crime Report. Oftentimes when we cover these cases, whether it be a single murder or the case of Brandon Martin and a triple murder, it's always interesting and sometimes heart-wrenching to hear the testimony or hear the words of an individual who had to walk upon that scene and see that brutal, brutal scene for the first time. Let's take a listen to the victim's cousin who described that case.
What did you do after seeing the body there? Well, I'm going to ask you another difficult question. Did you call out for anybody when you were there?
Not that I can think of.
And why? And what did you do after you saw the body?
I ran to the rental truck I was in and maneuvered it a few houses down and turned it around into a position to kind of aimed at the house, but to get away from the house while I was trying to call the police.
When you left the house, did you leave the front door open or did you close it? Or do you recall?
I don't recall.
Okay. Why did you not go inside the house?
In the military, we were taught to not go into a situation without having a tactical advantage, without numbering the enemy. And I had no idea what was going on. I was by myself. Just instincts. I didn't go in.
So that was Michael Anderson, and I apologize. That is the defendant's cousin, one of the victim's son. Remember, everyone's kind of related in this saga. So let's bring in our guest for our final chat here. We're looking at this. The evidence, again, I think we all are going to agree that it's pretty strong for the prosecution. Are there anything that you were seeing that might cripple the prosecution or might hinder the prosecution as we get this information? Jonna, let's start with you.
No, actually, I really think this is one of the few cases where guilt is a foregone conclusion. And the only reason that they're going through the motions here is because it is a death penalty case. And if we could just have a little fun, for lack of a better word, let's do a little behind the scenes, because we know as defense attorneys, to get to this point, to get to a point where you have a jury sitting going, why are we even having a trial? This guy is guilty as all get out. You know, a lot happens up to that point. And the fact that the defense here did not fashion a plea agreement that would have taken the death penalty off the table, not forced anybody into a trial, you know, had this defendant serve his life sentence or whatever he's going to serve based on his mental illness history, if there wasn't a full-blown insanity defense because it just simply didn't apply, I have to ask, how did we get here? Well, one of the ways we could have gotten there is, as Melba said, maybe the defendant said, I'm not pleading to anything. Okay, well, we have to follow what our clients want, even if we know better. Or the prosecution said, we're not dealing, because maybe there's a family member from one of the victims, unfortunately, who are pounding their fists on the table and saying, I want this guy to die. And that's another pressure behind the scenes that the public doesn't see by the time you pick a jury and go and walk into a courtroom. I'd be curious to know, just for ourselves, what happened here, because the jury's going to be scratching their head saying, guilty, no?
Yeah. We may actually, and again, this is a case that has two parts. It's going to be the guilt or innocent phase and then the sentencing phase. And I agree with you, Jonna, the guilt or innocent phase, that's done.
Done.
I think based on the evidence that we have here and the fact the defense is not contesting it, that conclusion, I think, is just around the corner. But in the sentencing phase, Melba would come to you. I think that's the one we're really going to have eyes on. And I think Jonna's questions may be answered there, because we're going to have that family member who wants death. We might get a family member who doesn't want death. Do you see a very conflicting and maybe tumultuous sentencing phase in this case because everyone's related and there's a bit of mental health issue here?
I think that there's going to be a very painful, very, very painful sentencing phase, because these are the types of situations where you may see family member pitted against family member, because I'm sure there's certain members of the family, especially the mother, who, you know, had fought so hard to try to get the proper mental health treatment for her son. And unfortunately, it did not come in a timely manner, which a separate discussion, mental health in America, you know, we don't have the proper infrastructure and we're not really making those resources accessible to everyone so that we can address these types of issues before they escalate to the point of violence. But, you know, looking at the sentencing phase, I do believe that there's going to be conflicting testimony from family members, some advocating for life in prison and others advocating for death. And when you see that sort of split, I tend to believe that juries will then side on come to the conclusion to give life in prison as opposed to the death penalty, because they're going to want to see more uniformity. And I think the defense's arguments around the fact that this is a mental health issue rather than evil intent is going to weigh very heavily on the jurors' minds, which again would result in a life verdict and not a death penalty verdict.
All right, Jonna, we only have a few minutes before we have to end the show, but I want to give you the opportunity to have a similar prediction. What do you think might come out of that sentencing phase if there is a mixed bag from the family wanting death or life?
I think you have to have a really hardcore death penalty jury in order to sentence this young man to death because of the mental health issue. Mental health is going to be a sympathy factor. It is a mitigating factor, in my opinion, in this particular case. And it's such a shame because, you know, look, in our country, we have a lot of people who suffer with mental health issues. They don't all commit murder, thankfully, but we do need to get better at how we help people with mental health issues and how we better manage them and promote the management themselves. This stuff can be treated. And unfortunately, it wasn't here. He probably will not get the death penalty.
I'm going to leave it there. You ladies said it best. Thank you very much for joining us today. We're going to continue the regular scheduled program after this. Have a nice day, everyone.